Okay, let's continue on. Um, all the rest, except the written indictment, is done openly in the presence of the judges, the justices of the peace, the inquest, the prisoner, and so many as will and can come so near as to hear it, and all depositions of witnesses given aloud, and all men may hear from the mouth of the depositors and witnesses what is said. All the rest, except the written indictment, is done openly in the presence of judges, justices of the peace, yada, yada, yada. But first, you got to give them the indictment. As has already been hinted, there is nothing about the origin of the early forms of the jury, or in particular of the criminal jury, to make it in any sense a popular institution. There was no manifest reason why it should not become a mere instrument of official power, as indeed the Tudor sovereign and their ministers tried to make it in the affairs of state. There was no obvious probability that the verdicts of juries would be just or independent or free of corruption. Indeed, they were far from satisfying all these conditions. In the disorderly times of the late Middle Ages, no one could ever have assigned any definite reason down to the 14th century why a jury should not hold a private inquiry out of the court. And while the procedure was unsettled, there were one or two practices tending to that way which might conceivably have become the model instead of the first being exceptional and then disappearing. But the national instinct of public prevailed. The most Norman and most royal element in the machinery of justice became a security against royal encroachment, a bulwark of freedom so beloved by Englishmen that pious fable ascribes its introduction to the hero King Alfred. Okay. A lot of old history, but basically, you got a guy called a coroner who's the keeper of the peace, and then you got these guys called justices of the peace that are under the coroner. Now, who's the head coroner? Because the coroner could be the sheriff, or can hold the sheriff's office, and it's not the 10-star sheriff. We're not talking him. All right, he has nothing to do with this. He's probably just a constable at best. The sheriff is a judge, or he has judicial power. Okay, what to next? Okay, so why is all this important? Well, because this is what they're doing to you. This is called a common recovery. And we're going to read through this, and I think when we get done, you'll see, oh, this is how they take somebody's property out of court case, like a foreclosure. When a tenant in fee simple grants a limited estate, such as an estate for life entail, the residual interact not thus disposed of is itself an estate capable of being separately dealt with. The same conveyance the grantor parts with it is called a remainder. Zoom this up here. If he keeps it, it is called a revision. The process of subdivision may be indefinitely repeated, the fee simple being regarded as a kind of fixed quantity out of which any number of particular estates may be carved. The smaller estate carved from the larger estate. The sum of them all make up the fee simple, as the bits of a Chinese puzzle make up the square, which is why we need to be able to untie the Gordian knot of conveyances when we get all this done and head out the door into the kingdom of heaven. A tenant in fee simple or fee simple absolute holds the greatest estate known to law. The word simple is used to indicate that there is no restrictions with respect to the inheritance characteristics of the estate. The word absolute emphasizes the estate is not defeasible upon happening of any event. It was not until the 15th century, however, that the completely effectual method of breaking through the statutory restraint of alienation, or barring the entail, as we say in regular use. Okay, so what does barring the entail mean? Traditionally, fee tail was created by words in the granted deed to A and the heirs of his body. The crucial difference between the words of conveyance of the words created a fee simple to A and his heirs is that heirs entail must be children begotten by the landowner. That's why the father's not listed on the birth certificate. They don't want you to know you have a dad. Land subject to these conditions has been said to be entail or entail, with restrictions themselves known as entailments. There was an elaborate form of collusive lawsuit called a recovery, first a feigned or fictitious recovery afterwards, when it was well established and familiar, a common recovery, and developed depending on efficiency of doctrine of warranty just mentioned. The lawsuit where the parties are not actually in disagreement, so that this is what a common recovery is, a lawsuit where the parties are not actually in disagreement. Well, this is collusive, but are cooperating to steer the court to some agreed upon conclusion. Such suits are not allowed in federal courts because they are not adversarial. It's a fictitious suit. Some agreement upon collusion's been done, or conclusion, on the conclusion. But it is collusion. The device in the simplest form was of this nature. The tenant entail we're going to call that them, the bank, being in possession, some person, we're going to call him them's attorney, acting in concert with him, would bring a real action. And a real action is to determine rights, title, and interest, and it takes a original writ under the Great Seal from the Court of Chancery, called a writ of right for the recovery of a freehold, whence the name of the proceeding, claiming to be himself the true owner. Right? So the attorney is going to say, hey, I'm the owner of the all caps name. He's claiming. And they're going to try to get you to agree and then get a writ of ejectment to get you kicked out because now you're trespassing on their property. The forms of action were different. The forms of action were the different procedures by which legal claim could be made in the early history of English common law. While in modern English law, as in most other legal systems, the focus is on the substance underlying an action, such as an existence of a legal right. In the early Middle Ages, the focus was on the procedure that was used, while the substantive law underlying that procedure came second. In other words, it is the form of action that was important and not the cause of action, as now. Yeah, well, what they're showing you is that this has been going on for hundreds of years. But the use of a writ of right could well result in trial by battle, which might be undesirable. A much quicker and less dangerous method might be to use a seize of novel dissession, or later to assert his right to the land indirectly through an action of ejectment, which is what they do now. So them, instead of defending his title, would vouch to warranty a third person, you, because on the deed of trust you're warranting their title, from whom or whose ancestor he would profess that his title was derived and was supposed to be bound to warrant the tenant against all comers. And he's going to hold up that deed of trust with your blue ink signature and say, hey, I got the legal title to the property, it's my property. Gatsby, you, I'm going to call you the vouchee, because you're the one who's going to warrant the title, as he was called, was brought in as a party and acknowledged the warranty. Is this your deed of trust? Brian, the attorney, the nominal plaintiff, then asked and obtained leave of the court to imperil or privately confer with you thus providing, if one may be so irreverent as to take an illustration from the stage, a sort of carpenter scene to cover the production of the final effect. Okay, come on outside, I want to talk to you. When Brian, the attorney, came back into court as if to report the result of the imparlance, it was found that you had disappeared, departed in contempt of court, as it was formally recorded. So when they called you out of court, they said, hey, you left court. That's contempt of court. They didn't do anything to Brian. He asked for an imparlance. Thereupon judgment, and I guess because you didn't, right, you left contempt of court. Thereupon judgment went to, by default, against you, and the lands were awarded to the attorney for the estate in fee simple. As to the bank, them, he and his heirs entail became entitled to recompense in lands of equal value against you by virtue of his supposed warranty. Thus, if Littleton, them, lineal heirs, who would otherwise have acceded to the entailed estate, were to make any claim on in the future, the answer to them would be their only remedy against you. Though those through whose default a stranger claiming in some wholly independent right, or in a technical phrase, by title paramount, had been deprived of their inheritance. Okay? So the bank's heirs could be whoever they assign it to. It remained to deal with the land according to the preconcerted arrangement. This was the affair not of the court but of the parties. If Littleton, them, purpose was to make a sale to the attorney, then Brian had only to keep the land in the judgment, and the court gave him full title and possession. If not, Brian, the attorney, would dispose of the according to Littleton, them, directions, by reconvening it, conveying it to Littleton for an estate in fee simple or otherwise as might be desired. The proceeding is here stated as above said in a simplest form, and is supposed to that all the steps in a collusive action are really taken in a regular way, and suppose that all the steps in a collusive action are really taken in a regular way. But the practice of later times, as described in Blackstone and minutely explained in the text writers of Law of Real Property, was more artificial and complex. The action was not merely conclusive, but fictitious. So not only is there collusion, it's fictitious. Nothing was really done in the Court of Common Pleas or its offices after the issuing of the writ which commenced the supposed proceeding. This is why your notice of lis pendens is not the suit. It's a notice of a suit. And the suits happen in another court. And you can see this by looking at the paperwork. Look at the tops of the paperwork and every piece of paper you have in a court case. And you're probably going to find one that's different. The name will be different. It could say the name of the city and then the county. And then the other one may just say the county. But if it says city, county, instead of just county, well, it's two different courts. Because it's the name of the court. And so they're opening these cases with a particular magistrate in another court that we don't know where it is. But I'm going to show you who I think he is. But the making up of the record stating, as in the case of a genuine action, the demand, defense, voucher, imparlance, default, judgment, the same equivalent fees, however, were paid to the officer of the court as if everything had been done in detail. Supposed to be proceeding, but the making up of a record, they're going to make one up. As in the case of a genuine action, the demand, defense, voucher, imparlance, default, and judgment. The same or equivalent fees, however, were paid to the officer of the court as if everything had been done in detail. Only where the party suffering the recovery was nobleman, he did appear in court, and the sergeant went through the form of pleading with him, as I learned on the authority of those who remember the old practice. See, I think we can use a writ of right and get a sergeant at law to represent us to get our estates back. And we're going to say we have the superior rights, title, and interest, and we really do. On the other hand, the form is complicated by additional precautions intended to make sure that every possible claim of the inheritable issue of the tenant entail, or of those who in their failure would become entitled under the further dispositions of grant entail, or ultimately of the original grantor and his heirs, would be effectually barred. They had to make it really complicated so you could never get your property back. Although none of it's done in court, it's all fictitious. And that's why we're going to put in a criminal complaint, because criminal complaints go to the Court of Chancery. The developed modern shape of the common recovery can hardly be understood by any one but special historical student of law, nor is there any need that it should be. It was possible, even after the developments, to raise doubts whether the fiction was in theory quite satisfying, and the rationalizing lawyers of the 18th century, while some of them at least inclined to think these doubt answerable, dismissed them as idle, and considered recoveries a common assurance, and not at all real transactions. The artificial reasoning by which the systematic justification of them was attempted being a thing in its nature inexplicable. In other words, what are you guys doing, right? You're committing fraud. One question, however, may naturally occur: the candid reader must not be neglected. What was not the vouchee, you, as we called him in our imaginary example, put in an extremely awkward position of being made liable to find recomps in the value of the tenant entails issue? And how was he induced to take such a risk? No doubt the position would have been anxious and dangerous for a man of substance. For the Middle Ages, at any rate, the court could not have confessed that it had lent its forms of its most solemn proceedings to a concerted evasion of the statute. But the trouble in this score was avoided by choosing a vouchee, you, someone who had notoriously had no lands to make recomps with, and therefore was, as we may say, not worth powder and shot. So since they took your property early on in your life, right, they're holding a legal title to your body, your land, you don't have anything to talk about. In later times, this offense, and they did that by having you go to a jurisdiction other than when your land is, in my opinion. You were born in a hospital which has a American flag hanging outside of it. You were born on federal territory. You are a United States, you are a citizen of the United States of America. You just haven't taken an oath to claim it and gotten a certificate of citizenship yet. In later times, the office was assigned, by settled usage, to the crier of the court, who in this capacity was called the common vouchee, and thus cheerfully, we presume, not ungainfully passed his life, or so much thereof as covered by the legal terms, in perpetual contempt of court, of common pleas, and liable to be fined at the king's discretion. Okay? So, who are these criers of the court? Every district judge may appoint a crier of the court. In Montana, the marshal is the executive officer of the court and shall act as crier of the court. So there could be court cases going on where somebody's standing in for you, this crier of the court. It may also be seen that the nominal plaintiff, the attorney in this action, must have been greatly trusted by the parties for judgment in favor. He disavows arrangement, insisted on making it seriously, and remain in the possession. He had the strongest possible title because he got it in court. It is possible that the earlier days of common recoveries, everything was left to his honor. But before later, at the end of the 15th century, going jurisdiction of the chancellor. Okay, so the chancellor is going to make sure he fulfills his undertaking because, hey, you signed your name to a contract. The learned reader may see more in Butler's notes, whatever this is, co.lit.191a. You can read it, which deal fully in this intricate subject. If you really want to know how they're doing it, you could go read that. I don't want to. What did I have left? So what are we doing with all this? Well, So in Michigan, first of all, a magistrate means a judge of the district court or a judge of a municipal court. That's who the magistrate is. Does not include the district court magistrate, except for the district court magistrate may exercise powers, jurisdiction, duties of magistrates if specially provided in this act. They got some certain things they can do. Okay. A complaint. A magistrate shall issue a warrant upon presentation of a proper complaint. Who's the magistrate? The magistrate is a judge of a district court or a judge of a municipal court. That's who it is in Michigan. And if you want to read more, this is MCL, Michigan Compiled Law 764.1a. Talks about complaints. 600.6434 talks about complaints. The complaint shall be verified. All right. And this is interesting. So, again, if you look at conservator of the peace in your statutes, you may find, like I did, that the director of the Michigan State Police is a conservator of the peace. And the Michigan State Police has an affidavit of fraud and forgery. Right? This is a complaint for fraud and forgery. Now, I don't know how much I'd fill out. Probably won't give my social security number. I might give them date of birth. I won't give them any of this stuff. I'll give them my name, telephone number, where I live, phone number, yada yada. I did not authorize anyone to use my name or personal information to seek money, credit, loans, goods, or services. I did not receive any benefits, money, goods, services as a result of events described in this report. I am willing to assist the prosecution of the persons who committed this fraud. Authorize release, credit, or information, law enforcement. I declare under penalty of perjury and have provided this affidavit true, correct, best of my knowledge. Right? You sign it, here's the complainant. You go before a notary. You just did a criminal complaint under oath to the state of Michigan, the Michigan State Police, which are conservators of the peace. That's one way you could do it. Right? You could write one up and put it under oath and just take it to a justice of the peace or a judge of the district court or the judge of the municipal courts here in Michigan. Let's look at some other ones here. If you look up citizens' complaints online, you should find lots to look at. Let's see if this one's going to open here. Citizens' complaint form, City of Milwaukee. Now these are mainly, they look like for things that the police have done incorrectly. Information about you, information about the incident, information about the employee, statements, description of incident, citizen complaint form, witnesses involved, yada yada, desired outcome, signature, notary, seal, verify complaint under oath. What would you say to the police? I would say that that ticket that they gave me was a promise to appear, and it's not a complaint. And so if they were to look in their file, there is no verified complaint. There is no complainant. The cop is going to end up being a complainant witness. He is not a complainant, and they will not put themselves as a complainant. And it says in the Michigan Vehicle Code that if you get stopped by a cop and you go down to the station, you say, I'm not answering, I deny it, unless they put a complaint under oath. They have to put it under oath, and they're not going to do it. Right? They're saying that the damn things are under oath, and I wish I had pulled that one up for this video, but I forgot to. I forgot. Okay, and what do we got? This one here. Police. This is just some definitions of, on a police complaint form: perjury, aggravated perjury. Complaint to be in writing and signed by the complainant. Copy of a complaint to be given to the officer or employee. Complaints by citizens. Police complaint form. One of two. Just yada yada yada. Boom. Seal. You're going before a notary, right? You get done with this, you just put it under oath. So I'm not saying to use these, but they just give you an idea of what information they're looking for on a complaint put under oath. So you can find them under police complaint, you can find it under citizens complaint, all sorts of them to look at. And I wanted to see if I could really quickly find this. And we'll call this one done. But where was it? Criminal charges. Where's that thing on the judge? Illinois. Here we go. State Court of Michigan. In the District Court, hyphen 12th Judicial District. I think that's the way we're supposed to put our district courts if we were to put something into them. Instead of like the 63rd District Court, 63B District Court like I'm in, it would be in the District Court, 63rd B Judicial District. But this is appointment of a non-attorney magistrate. And here's some interesting things. So it's ordered that this guy here, Michael John Dillon, number one, he is a registered elector in the district. That's where you register, in the district. We were trying to register as registered electors here in Michigan because it's one of the ways you would be seen living. You have just claimed your domicile. And it should be done through the township when you read about it in the Michigan compiled laws. But, found out that those guys don't have the proper oath. Later found out on the last video I did that those the townships don't even exist anymore. They were declared unconstitutional by the federal government because they had uneven populations, and it had to be, they wanted the populations to be more even. And so we went to these districts. We have county commissioners. And so if you want to register, it looks like you do it in the district of a county commissioner, not in a township. And then these districts have the same local government power that the township should have had. Nevertheless, I use a registered elector. That's interesting. So they can't tell you it doesn't happen. It is a registered elector in the district. Now they're going to give him special powers to reign for certain things, but mainly based off of these different, look at these, it's sport fishing, wildlife. What you're looking at is forestry law. This is the forester's frickin' magistrate. And there's one of them in here that has to do with trespass, the Recreational Trespass Act. I tried to use this myself against Consumers Power, and I had a magistrate tell me, well, it's not that you're not correct. I'm just not inclined to issue any warrants. And kind of find out I hadn't put my complaint under oath at the time and may have made a couple other mistakes. But in this act, you can claim actual property damage. And it's done on a small claims form, which usually has a $3,000 limit. You're not even putting a limit in there. You're just claiming actual property damage. You don't put a dollar amount in. And this is the trespass that they're talking about. Once they can get that it's your property, or get a judgment that it's their property, now they're going to get a writ of possession for trespass and kick you off the property. And so this guy here, this is the magistrate that they take their claims to, I believe, to open up the cases. This is the other court. This is in the district court, 12th Judicial District, not 12th District Court like we would normally know it here. It's the district court, 12th Judicial District. And this is the magistrate that's taking the claims of the attorneys. This is where the Liz Pendant's suit pending started. And this guy was put in on an administrative order. He's, I don't know if that makes him an administrative judge or not, but he's not a justice of the peace that can take your claim. He only has jurisdiction in certain matters. He's the one that they were talking about here. Magistrate does not include district court magistrates, right? That's who this guy is. He's a district court magistrate. Yeah. As magistrate in approval of the Jackson County Board of Commissioners. Okay, so this is the other court. That's all I can tell you. There is another court. We need to take ours to the judges. See, because it says to us, I don't remember where the frick I put it. We need to take ours judges of the district court, judges of the municipal court. Magistrate does not include district court magistrate, except where that district court magistrate may exercise the powers, jurisdiction, and duties of a magistrate, especially provided in this act, yada, yada, yada. Anyways, they gave him specific things to be responsible for. And they all have to do with forestry stuff. Sports fishing, wildlife, marine safety, motor carrier, dog laws, liquor licenses, natural resources, littering, hunting, recreation, right? This is forest law. Forest law was the hated by all the people of England, right? They ran on their own clock. So where it talked before about the coroner being the person between your direct connection to the king to get around the intermediate lords, this would be one of them, right? This is how you get around the forest laws. You go directly to the king. So, okay, well, that's about it. It's a lot to go through. I probably went too fast. I usually do, but really all I'm looking at is if you were to go online, look up Stubbs Selected Charters, 8th edition, 1895, boom. Look up things on the King's Peace, King''S, King's Peace. Understand what a magistrate is and what a criminal complaint is and where to take one and make one up. We're going to go see what happens. We got people trying right now. Great. We'll talk to y'all later. See ya.